Welcome back to the Toy Report. On June 23, 2022, the United States Supreme Court released its Bruen decision, ruling that the ability to carry a pistol in public was a constitutional right under the Second Amendment. But the Bruen Court went further than just the outcome of the case. Bruen set an entirely new standard the federal courts are to use when deciding cases involving the right to keep their arms. In this video, we'll talk about why it matters. Although it has only been a year since the court released the decision, Bruen is already changing the legal landscape in terms of federal court decisions in cases involving the right to keep and bear arms. As you'll see, the impact has been profound. Some Americans will be thrilled, while others will be beside themselves. We'll keep this brief because it isn't our goal today to discuss every firearms-related case since Bruen was decided. We simply believe America has reached a point where a pattern is emerging, and people might care to know in what direction the decisions are heading. When Bruen was released, we started telling our family and friends that the decision was essentially a death blow for the vast majority of gun control laws across the United States. It wasn't just that the court struck down New York State's May-issue concealed carry permit scheme. It was in doing so that the court also established a new test for lower courts to use when considering whether a state or federal statute violates the right to keep and bear arms and is thus unconstitutional. We dubbed that the Bruen test. The pre-Bruen test in most firearms-related cases pivoted on the vague notion of public good, which is, of course, absurd, because you can light up 10 federal judges and ask them to explain public good relating to firearms and get 10 different answers. It was an absurd paradigm because our unalienable rights are never to be ruled upon by a court on the basis of the personal opinion of an individual judge or even a group of judges. We can all agree that no matter which unalienable right is being considered by a court, individual personal opinions of judges isn't the correct standard. In fact, it's not really a standard at all. Allowing judges to rule based on their personal opinions creates an impermissible judicial freefall. The Bruen test is a new standard, but what is it? If you watch a lot of pro-Second Amendment videos, you've probably heard of it more than 1,000 times. So, what is the Bruen test? It is essentially this. In Bruen, the court said the right to keep and bear arms had a discernible meaning and character at the time the founders ratified the Bill of Rights, and therefore, that meaning and character is what defines that right today. In short, the court said the views of the founding generation concerning the ownership and carrying of arms of any type, which includes firearms, are constitutionally fixed by consideration of how the founders would have viewed legislation impacting a citizen's right to keep and bear arms. To be clear, the court's ruling was a complete repudiation of the living Constitution theory. There are two camps on constitutional interpretation. One is the originalist view, holding the document's meaning exactly what the men who wrote it intended when they wrote the words, and the states ratified those words. The other is the living Constitution theory. The originalist model tries to identify the principles of liberty and good governance behind the Constitution, supporting and carrying those principles forward into our modern circumstances. An example of that would be the principle of freedom of the press. It exists just as much today when we have computers, super high-speed industrial printing, or an online digital presence as when cutting-edge technology was a hand-cranked wooden printing press. The press is the press. The living Constitution theory argues the meaning and character of the Constitution and its amendments are dynamic, subject to the whims of the current generation of judges and society at large. Essentially, the living Constitution theory argues that while the Constitution and its amendments might have had a specific meaning and character at the time of ratification, those fixed concepts of our Constitution should be modified to meet the current public's perception of what our Constitution should mean. I'll leave it to you to determine which side of this issue you prefer. But as we move forward, understand that the Bruen test is to be applied by the federal courts when considering the constitutionality of state or federal statutes that impact the right to keep and bear arms. How do federal courts apply the Bruen test? I think a few examples will provide a clear picture. Let's look at the law as it stood on the eve of the Bruen decision. Under federal law, it is illegal for a federal licensed firearms dealer, or FFL, to sell any handgun to anyone under the age of 21. On the eve of the decision, the federal law prohibiting handgun sales to persons under 21 years of age came under scrutiny in a federal court in Texas. The federal court hearing the case held that the federal law prohibiting FFLs from selling handguns to people under 21 years of age violated the Second Amendment. The court's reasoning was interesting. First, the court took into account the fact that 18 to 20-year-olds are, according to federal law, adults. Next, the court examined the fact that in 1776 and the decades following that, the primary consideration for the drafters of the Constitution was not age, but whether a person was mature enough to bear arms. The Texas federal court noted that the colonists considered anyone who could provide their own arms for militia service was by definition mature enough to be entrusted with the same rights as their parents and grandparents. The Texas court held that by setting the minimum age to purchase a handgun at 21, the federal government was interfering with the right of law-abiding adults to exercise their rights as the Constitution guarantees. Therefore, in that particular case, the court held the federal law prohibiting the handgun sales to persons under 21 violated the Second Amendment. Now, remember, this is the Bruen test. In a living Constitution world, a judge could look at the same case and rule that the founders would have wanted an age limitation because 18 to 20-year-olds can be irresponsible. That's exactly what the living Constitution crowd argued in court. The court noted that such a determination would be, according to the Bruen test, the opinions of modern society as opposed to the fixed constitutional meaning and character that is defined by the views of the founders. Here's another example. Let's look at the case in the North Carolina Federal District Court in which the defendant challenged a state statute that prohibited anyone convicted of domestic violence from possessing any type of firearm. The defendant in that case was in a relationship that ended badly. The plaintiff in that case went to court and filed a domestic violence complaint. When the judge ruled on the case, he also granted the woman a domestic violence restraining order. Under North Carolina law, that caused the defendant to become a prohibited person, meaning he could no longer own, possess, or transport firearms. The defendant argued the domestic violence statutes ran afoul of the Second Amendment and brought the case before the federal court. The court agreed. The court found that the restraining order was granted under what the court called low-hanging fruit circumstances, meaning that no showing of physical violence was required to grant the domestic violence restraining order. The court noted that the restraining order under North Carolina law could be granted on something as innocuous as a stern look or even an argument. The court ruled that because the restraining order was granted under such circumstances, the defendant was deprived of his Second Amendment right without due process of law. In other words, the court held that the defendant was deprived of his Second Amendment rights without being given the opportunity to confront his accuser or challenge the allegations against him. Again, if we were operating under the living Constitution theory, the court could have come to a different conclusion. The court could have argued that the founders would have wanted women to have an easy pathway to restraining orders, and anyone against whom a restraining order was issued would be automatically a prohibited person. The court found that such a determination would be a contemporary opinion, not a constitutional interpretation. The court held that the restraining order must be issued after a judicial finding of physical violence or threats of violence, thereby meeting the constitutional definition of due process. We are ending it there. We believe these two examples clearly illustrate how the Bruen test has changed the legal landscape in the federal courts. Again, the impact has been profound. We predict that the number of gun control laws being declared unconstitutional will increase exponentially in the coming years. It is important to recognize, however, that the Bruen test is not without its critics. Some argue that it gives too much power to judges and allows them to impose their own subjective interpretation on constitutional rights. They contend that the original intent should be the guiding principle in interpreting the Second Amendment rather than contemporary societal opinions. Critics also express concerns about the potential for inconsistent rulings and the lack of clarity in determining what constitutes a historically protected right. Despite these criticisms, the point stands. Bruen will end gun control laws across America. Please note that this is not legal advice. If you have legal concerns, you should consult with a qualified legal professional. And that's all the time we have for today. If you think we missed anything on Bruen, sound it off in the comments. Please like, share, subscribe, and click on the little bell icon to be notified of all future videos. Thanks and have a good one.